Thank you to GTAN and the other organizers for the invitation to speak at this forum. Um, I'll try to keep the presentation as brief as possible because I know that a lot of you will probably have more specific questions on the issue of POGO. I'll try to stick to the basics and just give an overview of what we're talking about in terms of the law governing POGO, as well as some of the current concerns relating to the legal and I suppose extra legal considerations regarding this issue. Okay, so briefly, these are legal and political perspectives on the POGO issue. Start with an overview, just a basic fact. POGO actually stands for Philippine Offshore Gaming Operators. Okay, it's an acronym. And Philippine Offshore Gaming Operators, under the definition of the PAGCOR rules, are actually online gambling firms which operate in the Philippines, but whose customers are actually found outside of the country. Technically, under the terms of the PAGCOR rules, legal POGOs, those licensed by the PAGCOR, are actually prohibited from catering to persons that are in the Philippines, as well as to Filipinos, regardless of their location. So if you're a Filipino citizen, you cannot be a POGO customer, whether you are in the Philippines or not. If you are not a Filipino citizen, but you are in the Philippines, then again, the POGO should not be actually providing any services to you. And the last class of persons prohibited from receiving POGO services will be people in countries where offshore gambling is actually illegal. So take note of the idea. These are gambling operations. They are in the Philippines, but the actual gambling itself does not cater to Filipino clients or to people within the Philippines. They are outward looking in that particular sense. So these are online. The customers access the services through the internet. And again, legally, under the terms of the PAGCOR licenses, they cannot be intended for people within the Philippine territory itself. That's the basic overview. Now, what is the legal basis for POGO? General rule that we have is gambling in the Philippines is actually illegal, or in the case of specific types of gambling, like for instance, cockfighting, they are governed by specific laws. However, there is one huge exception to the rule on gambling in the Philippines, and that is PD 1869, issued during the Marcos dictatorship. And PD 1869 actually is the PAGCOR Charter. It creates a corporate entity, a government corporation, called the Philippine Amusements and Gaming Corporation, which is authorized to actually license gambling operators. So the intention behind PD 1869 is to consolidate and centralize all types of gambling operations within the Philippines, except for those already governed by special laws. And as I said earlier, that an example of that would be cockfighting, which has its own law, and put them under the authority of PAGCOR, which will license gambling operators and in so doing, earn revenues for the government. That's the idea behind 1869. And supposedly, under the very, very broad powers granted to PAGCOR under this law, they, in 2016, September of 2016, enacted a set of rules, rules and regulations governing Philippine offshore gambling operations, or POGOs. So to be clear, when POGOs first entered the picture, when they first started setting up within the Philippines in September of 2016 under the Duterte administration, there was actually no specific law authorizing POGOs to operate. It was only an executive issuance by PAGCOR supposedly under the power, the broad power granted to it under its charter, PD 1869. So let's be clear about that. POGOs entered the picture not through an enactment of Congress, at least initially, but only through the action of the board of directors of the Philippine Amusements and Gaming Corporation. In fact, in the case filed before the Supreme Court several years ago, challenging the legality of POGOs, this was one of the main contentions. That PAGCOR's authority under PD 1869 did not actually authorize it to license POGOs. But we'll get to that in more detail a bit later. Okay. Now, be that as it may, okay, even if initially POGOs entered the Philippines by way of a PAGCOR board resolution, in essence, and not a law, in September of 2021, 5 years later, still during the Duterte administration, Congress actually did pass a law. This is Republic Act 11590, 11590. And although it did not explicitly authorize the operation of POGOs, it did not explicitly provide for a mechanism by which POGOs would be licensed because mainly it dealt with taxation. RA 11590 actually involves amendments to the National Internal Revenue Code of the Philippines, the Bible of Philippine tax law. And the amendment actually included a new taxable entity, which are POGOs. Okay. And in the wording of 11590, it actually indirectly recognized the authority of PAGCOR to license POGOs because it said that POGOs are these entities which are actually licensed either by PAGCOR or by one of the export processing zone authorities because some POGOs at that point were located within export processing zones. And so long as they are licensed by these entities, they are considered as POGOs and they are subject to this tax, which we are now imposing. That's essentially what RA 11590 provides. So, in other words, by creating a law which explicitly taxes POGOs, it could be argued that Congress indirectly lent its imprimatur of approval to the existence of already licensed POGOs under the previously licensed by PAGCOR under its rules. But again, we'll get back to this particular point in a bit. So just to be clear, currently there are two legal documents that you can look at if you are looking for a legal foundation for why POGOs can operate in the Philippines. One is a set of essentially administrative regulations issued by PAGCOR, and one is an indirect recognition of POGOs as a taxable entity under Republic Act 11590. Okay, passed just 3 years ago. Okay, next. Okay, so what are some of the legal issues that arise given this context? Well, as I said earlier, the initial question is PAGCOR actually empowered to license POGOs purely under its authority under PD 1869? I have doubts. One, because the provision that PAGCOR is citing is a general provision under PD 1869, which defines the objectives of the law and the creation of PAGCOR, which is to centralize all gambling operations, to provide order, organization, and essentially create a revenue source for the national government. But in the immediate section, after that declaration of objective, it is also made clear that the intention of the law is to cover gambling operations within Philippine territory. In other words, gambling which already occurs within the Philippines. Okay? You're a gambling operator. Let's say you're running a card game, for example, or a casino. You go to PAGCOR to have that license because you are operating within Philippine territory. But as I mentioned at the very, very start, POGOs are defined as entities which, although they do provide online gambling services, They do not provide online gambling services within Philippine territory. So while they may be located in the Philippines, physically, their dealers, their operations are here, none of their clients legally can be from the Philippines. There is an explicit bar to providing gambling services to anyone within Philippine territory. So arguably, the question now is, does the PAGCOR Charter, which is specific to authorizing PAGCOR to license gambling within the Philippines, can it be interpreted to extend to gambling operations which are not technically taking place within the Philippines, but within the cybersphere and catering to clients literally outside of Philippine territory? That's a big question mark. Can you actually expand this old Marcos era presidential decree to now grant this rather dramatic expansion of the authority of PAGCOR in at least in the specific case of online gambling? So that's a question mark. As I said, this was raised before the Supreme Court, but unfortunately, the court declined to rule on the merits. It did not rule on the substance of the arguments as to whether PAGCOR was actually authorized under PD 1869. Instead, it elected to dismiss the case on the ground that the hierarchy of courts was not observed. In other words, dapat nag-file muna kayo sa lower court, hindi kayo dumiretso sa amin. But we're not ruling on the substantial question of whether or not the PAGCOR issuance was actually valid, a valid exercise of its power under PD 1869. So that remains an open question at this point. Okay. And a related question to this is really now the second point I raise here. Can PAGCOR actually license gambling outside of Philippine territory? Because technically what is happening is people in other jurisdictions are gambling online, and it is and that gambling is not actually being authorized by the laws of their own countries or their own states. It is technically gambling which is taking place under the aegis of PAGCOR, a Philippine government corporation. So again, there is a question of authority and jurisdiction and legality here. While, yeah, I understand there is a limitation that if there is an explicit provision against gambling, PAGCOR will not allow a POGO license to actually cover that. Still, there are a number of restrictions that can fall short of an actual prohibition, which are still actually, in a way, crossed or transgressed when PAGCOR licenses gambling outside of its own territory. So again, that's a question that would have been interesting if it had been confronted and directly resolved in a court. And then finally, what is the effect of Republic Act 11590? As I mentioned earlier, the intention clearly is to tax. Okay, the main intention is to tax POGOs. That's the objective. That's the very, very clear objective behind 11590. But does taxing POGOs now implicitly or impliedly also legitimize them, regardless of any irregularity in the licensing portion to begin with? Okay. In other words, is the conversation on the power of PAGCOR to license POGOs under PD 1869 in a way superseded by the fact that you already have congressional enactments that indirectly recognize that authority? My take is it shouldn't, because again, it's a different conversation on whether an entity can be taxed to whether that entity is operating validly to begin with. I'm sure all of you are familiar with the the historical case of Al Capone in Chicago in the United States. He was actually done for tax evasion, and the taxes that he failed to pay were for activities which were illegal at that time. Because one of the rules in taxation is that essentially taxation is source blind. In other words, regardless of how you generate income within Philippine territory, you are subject to a tax. So I would argue that the simple fact that there is a law recognizing or saying that POGOs should be taxed this rate does not reach back automatically and immediately legitimize their existence unless it can be shown that to begin with, the creation or licensing of POGOs under the charter was already going to be justified. Because, Congress could simply have legalized POGOs explicitly under 11,590, but it did not do so and instead only focused on the taxation aspect. So at this point, my position personally is that there is still no solid legal foundation for the existence of POGOs, and therefore the implication is it will not require a law, the enactment of Congress by a law, to actually ban them within the Philippines if that is the direction of the current administration or the government. It will only require action on the part of the executive. On. Okay. So, aside from the legal questions, what are some of the other non-legal, perhaps political concerns that we need to talk about in relation to POGO? Well, first of all, is their involvement with criminal syndicates. Now, this is fairly well documented. Investigations by both Philippine law enforcement authorities like the NBI and the PNP, as well as analysis by experts working on the issue of criminal syndicates and gambling within the Asia-Pacific region, have actually pointed to links between POGOs in the Philippines and other countries with Chinese criminal syndicates. Okay, that's a fairly well-established fact. Currently, the Presidential Anti-Organized Crime Commission estimates that there are about or over 300 illegal POGOs in the Philippines. Illegal meaning unlicensed by PAGCOR, operating without a license or in violation of the terms of probably a pre-issued license. In contrast, there are around 50 that continue to operate under license by the government. Now, the 300 might seem alarming, and it is, but we have to understand that not all of the 300 illegal POGOs operating are operating at the same scale. We tend to think of POGOs in terms of the POGOs that first came in during the Duterte administration, where you had POGOs that had tens of thousands of employees that rented office spaces in Makati and Ortigas and other major urban centers. So big, well-organized, well-funded organizations. Now, a lot of the 300 illegal POGOs currently identified by PAUSI are much smaller. Some of them are literally mom and pop operations with, I don't know, 15 to 20 employees. Now, that doesn't mean to say that they are not a concern. They are, because obviously no matter how small you are, you can still actually be engaged in criminal activity. And I said, most of these POGOs are to a greater or lesser extent. But in terms of the total volume of the problem that we are talking about, there has actually been a reduction from the Duterte administration to now. Particularly, the cutoff point is COVID and the lockdowns. During COVID-19, a lot of the POGOs, which started operations 2016 onward, actually shuttered their doors and moved out. Okay. But still, you have around over 300 still operating. You have 50 licensed and continuing to operate large scale. And both types have actually been linked to crime syndicates, scams, smuggling, human trafficking, drugs, torture. Okay, so a whole slew of very, very serious crimes ranging from financial fraud to smuggling to outright harming of human beings through human trafficking, the distribution of drugs, and actually torture. You will ask, bakit torture? Why are POGOs involved in torture? Well, in some of the raids, they actually discovered that there were torture chambers, and the idea here is what happens is some of the people who gamble Well, they whether they actually lose or the games are rigged and they end up in tremendous amounts of debt. And to ensure payment, they are actually kidnapped, abducted, subjected to torture and punishment within the offices of these POGO. So it's really a pretty serious and quite shocking um, development that this is happening within our country and uh, at least semi-officially under the auspices of some form of legal cover through licensing by PAGCOR. Okay. Now, a second and related point is the issue of political corruption. Okay. Now, Duterte in 2016 opened the door to POGOs during his term. September 2016, few months after he assumed office, you already had PAGCOR authorizing the entry of POGOs. And although there has been some reduction under the new administration of the second Marcos, Marcos has actually allowed old licensees to continue operating. Okay. So the 50 licensed by the government that are continuing to operate, well, the bulk of them were actually authorized under the previous administration. And the more alarming thing is that some of the POGOs currently operating legally actually have close links to Marcos officials. I'm sure, I don't know whether you've heard of Island Cove and Oriental. Island Cove is owned by the Remulla family. And over the past few weeks, in the wake of all the news and investigations and raids on illegal POGOs, the news that the Remullas were actually leasing and property to a large POGO operator in Cavite itself. And that this group actually was able to secure a specific contract with Meralco to provide and ensure power for their facility should be ringing alarm bells because you have a high official whose family, no less than the Secretary of Justice, actually in business with POGOs. In fact, news reports have it that he ordered the NBI to see several investigations into some POGOs that the NBI was actually looking into. So the other aspect, aside from connections to Chinese criminal syndicates operating transnationally, okay, and the increase in criminality related to things like smuggling, drugs, human trafficking, and so on, is actually the links to political corruption. A lot of these POGOs, the bigger ones in particular, have connections and have protection at the highest echelons of government. Obviously, during the Duterte administration, this was the rule rather than the exception. Now, you still have the same thing going on with some officials under the Marcos administration. And, that is clearly a concern. PAGCOR, of course, has made no secret of the fact that it is for the continuation of POGO operations, citing the revenues that POGO supposedly generate in this regard. And then lastly, the last concern that has cropped up more recently is the issue of national security. This came about, well, due to several factors. One is the discovery of supposedly People's Liberation Army Chinese military uniforms in one of the raids. Okay, so they gave rise to speculations that maybe some of these POGOs are being used as fronts for infiltration by actual members of the Chinese military in preparation for some kind of military action similar to supposedly what happened before World War II when certain Japanese nationals were deployed ahead of the invasion and so on. Okay. The other factor which led to this particular line of speculation and this concern is really the case of uh, Alice Guo, or as I should call her now, Guo Huaping, the Chinese national who was able to successfully run and be elected as mayor of Bamban in Tarlac. Okay? And the idea there is, well, if a fake Filipino using apparently falsified documents can assume that identity of a Filipino citizen and then run for local office and then provide some kind of political legal cover at the local level for a POGO operating within their territorial jurisdiction. That's seemingly what happened in the Guo case. Well, it's also an issue that involves national security because now you have foreign nationals passing themselves off as Filipino and becoming part of the government apparatus. Now, whether their purpose in doing so is to simply protect Pogos. And in the case of Guo, that's clearly one of the things that she did. She was involved in the Pogo operation in Bamban, Tarlac. The other question is, well, what else can we expect this kind of strategy to be implemented as? Right now, it's criminal syndicates, but you know, if it can be done, then it can also be done in a more national security related concern, infiltration of local governments for the purpose of political cooptation, for example. So that's clearly a concern that has arisen also in relation to these POGOs because so many of them have come in. So many foreign nationals have also come in, supposedly, ostensibly under work permits related to POGO operations. But their entry and the entry of and the flagging of cases like the Guo case gave rise to a serious concern regarding how vulnerable we may be to this type of infiltration of foreign nationals who might have hostile intentions towards the Philippine state at some point in time. Okay. So, what's next, therefore, given all this? Well, the big question really is, are we moving towards a complete ban or simply a stricter set of regulations? Because right now, Pogo has come into the picture. The Guo case has shed a lot of light on it. Pausi has been talking about all the harmful effects of Pogo because of crime. So there is obviously a huge public clamor to do something about it. But the question is, will that public clamor be responded to by the current administration by an outright ban, as some people are calling for? In fact, the lower house, the House of Representatives, passed a bill banning POGOs, calling for an absolute ban. Some senators have also been calling for an absolute ban, but as of now, that question is still up in the air. Also, do we really need a law? And as I said earlier, my personal position is the executive on its own can actually implement a ban here without necessarily waiting for Congress to take action. Okay, but there is we should expect that there should be a longer debate on whether regulation or ban is really the key here. And then finally, I've been talking about legal or licensed pogos or illegal pogos all day, but really, is there a difference? Because the data would tend to show that connections to both criminal syndicates and criminality exist for both legal and illegal pogos. In other words, the wrongful effects of pogo operations are not, strictly speaking, confined only to those which have no licenses with PAGCOR. Legal pogos licensed under PAGCOR also have proven problematic. And so the question is there really a distinction, and should we continue to actually make a distinction as we move into the conversation of whether there should be a regulation or a ban? Okay, so I guess I will stop with that. Thank you for listening, and if you have questions during the open forum, I'll be happy to answer them. Thank you very much, and good morning, good evening, good afternoon.